You're listening to the Bloomberg Law Podcast. Catch us weekdays at 10 p.m. Eastern on Bloomberg.com, the iHeartRadio app, and the Bloomberg Business app. Or listen on demand wherever you get your podcasts.
Welcome to the Bloomberg Law Show. I'm Kimberly Robinson.
And I'm Lydia Wheeler. We're filling in for June Grasso, who's out this week.
Ahead in this hour, we'll talk about the salary war that's heating up between major law firms, many of whom have bumped up associate salaries to a whopping $225,000 for the most senior attorneys.
But first, in a contentious hearing, Senate Democrats last week approved subpoenas for individuals at the heart of recent ethics scandals involving Justices Clarence Thomas and Samuel Alito.
Now, for the second time as my chairmanship, the Republicans have invoked the 2-hour rule as they did on the Vanita Gupta nomination, which means that we literally have until 12 o'clock to complete our business.
No, we have next week, and we have the week after that, and we have the week after that. What is the urgency here? Give me a break. You got a bill
Graham,
on the floor.
Senator Graham, would you yield to a question?
Please let me finish.
The chair has the floor. We will therefore proceed with a vote on the chair's November 2nd, 2023 motion to authorize subpoenas relating to the committee's Supreme Court ethics investigation. The clerk will call the roll.
That was Senate Judiciary Chairman Dick Durbin trying to get a roll call. The measure eventually passed along a party line vote. Here to talk with us about that is Bloomberg News' Emily Birnbaum. Thanks so much for joining us.
Thanks so much for having me.
All right, Emily, can you remind listeners what prompted the Senate committee's interest in Supreme Court ethics?
There has been a string of really amazing revelatory reports from ProPublica and other news organizations about potential ethics concerns at the Supreme Court. So that includes big GOP donors taking Clarence Thomas and Samuel Alito on luxury trips. That includes Harlan Crow, a GOP donor, having a decades-long, very close relationship with Clarence Thomas, in which he's taken him around the world. So basically all of this has brought up, what should the Supreme Court justices have to disclose in their financial reports? What should they not be doing? A lot of conflict of interest questions.
So who exactly is the Judiciary Committee trying to subpoena here, and what information are Democrats seeking from these witnesses?
They are trying to figure out the breadth of the gifts from GOP mega donor Harlan Crow and Leonard Leo, former president of the Federalist Society. So the gifts that either Crow gave to the Supreme Court justices or that Leo organized for them. They're looking for a detailed accounting of transportation, lodging, gifts over the last couple of decades.
And so far, what has been the response from Crow and from Leo?
Crow and Leo have both said the committee's investigation is a political stunt. It's part of the Democrats' frustration with the rightward direction of the court under the conservative supermajority. So Crow's been a little bit more responsive. He's offered 5 years worth of information. Democrats say that's not enough. And Leo, on the other hand, says that he just won't engage. He says it's a politicized vendetta.
Is anybody else the subject of the committee's attention? And if so, what do they have to say?
Yeah, they were also looking at Robin Arkley. So he's a real estate businessman who owned the fishing lodge where Justice Samuel Alito stayed in a trip that he didn't disclose years ago. But the committee decided not to subpoena Arkley. They said that he had begun cooperating. This all comes after this same committee tried to bring in Chief Justice John Roberts to testify himself about some of these ethics scandals. Roberts rebuffed them. They don't really have any authority to bring in Supreme Court justices, so they have turned their attention to these big GOP donors and fundraisers behind the justices.
And so, Emily, what is it that, members of the Senate hope to do with this information? Have they given any indication about, sort of what the long game is here?
Yeah, they say it's part of an investigation to inform legislation. So they do have Supreme Court ethics code legislation that they passed out of the committee but haven't brought to the floor. But they say they need to see the full extent of the problem before they can come up with a proper solution. So I think it's about really figuring out if there are more trips that haven't been disclosed, more gifts that haven't been disclosed, and why or why not. So it's part of this broader probe. But there's a constitutional question around all of this, which is, does Congress have the authority to even write legislation that applies to the Supreme Court? And that is the elephant in the room through this whole thing.
Now, we know we got a reaction from Harlan Crow and Leonard Leo, calling this a political stunt. But are they actually going to comply with the subpoenas? Do they intend to, do you think?
So far, they're saying that they don't intend to. Crow's office has been a little bit more mild, so he said he's ready to keep engaging with the committee in good faith, but he described the subpoena as invalid. Leonard Leo also said the subpoena is invalid, so both of them have set themselves up as antagonistic to these subpoenas, so we're getting into really complicated area.
Emily, I do want to get into sort of that whole complicated procedure that could happen next, but just wondering why it is that Crow and Leo are saying that these are invalid. I mean, what about the processes have them claiming that it's invalid?
So Leo especially has been claiming it's invalid from the start because of some of those constitutional questions. They say the legislative agenda here is not worth pursuing, and therefore anything that they do as part of the investigation might be unconstitutional. So that's been what he said from the beginning, but now there are these procedural issues that we heard about at the beginning of the episode. We heard that clip. There are rules on the committee that you need a certain number of minority senator members present when you take a vote and when you conduct business. All of the Republicans left the room before these subpoenas were authorized. So that's a little bit in the weeds about congressional procedure, but it actually could really matter in terms of whether these subpoenas are enforceable.
So what happens here if Harlan Crow and Leonard Leo defy the subpoenas? Is this a matter that could make its way all the way to the Supreme Court?
It definitely could. Playing out the hypothetical, lawmakers could certify a contempt citation for Leo or Crow for criminal prosecution for defying the subpoena, or they could turn to the courts, take a civil route, try to enforce a subpoena by seeking a civil judgment, declaring the recipient of the subpoena has to comply. And through the appeals process, those could arrive before the Supreme Court. And that would get really complex because it is about an investigation into the Supreme Court. So then I think that poses recusal questions that the justices haven't necessarily had to face before. But they do first need 60 votes on the Senate floor to push forward the subpoenas, and they don't seem to have that right now, given Republicans hold 49 seats in the Senate. So that's their first most important hurdle.
While all this has sort of been playing out in the Senate, we have seen the justices release their own ethics code. Did that change the game at all for Senate Democrats and their calculus on these subpoenas?
It doesn't seem like it has. They postponed the vote just a couple days after the Supreme Court put out their ethics code. They said, we need to take some time to dig into this. But ultimately what they're looking for is an enforcement mechanism for ethics standards. So the ethics code that the Supreme Court put out codified standards that they said they already abide by. But activists and Democratic lawmakers have said, well, you need oversight. If you're going to have a set of rules, you have to face repercussions if you don't follow those rules. You have to have someone overseeing whether you are following the standards you set for yourself. So it's about enforcement at this point. So that's where Congress could step in.
Well, coming up on the program, we'll get more on the Senate Supreme Court ethics subpoenas with Emily Birnbaum. Remember, you can always get the latest legal news by listening to our Bloomberg Law podcast on Apple, Spotify, or wherever you get your podcasts. I'm Kimberly Robinson.
And I'm Lydia Wheeler. This is Bloomberg.
You're listening to the Bloomberg Law Podcast. Catch the program weekdays at 10 p.m. Eastern on Bloomberg Radio, the TuneIn app, Bloomberg.com, and the Bloomberg Business app. You can also listen live on Amazon Alexa from our flagship New York station. Just say, Alexa, play Bloomberg 1130.
I'm Kimberly Robinson.
And I'm Lydia Wheeler, in for June Grasso.
I don't buy anything you just said. Let's just be real blunt and direct. This is garbage. If you really thought this was a problem, why don't you bring up the Supreme Court Ethics, Recusal, and Transparency Act that was passed September the 5th, 2023, in this committee to fix the problem you just talked about. This bill is never going to see the light of the day. Go to Senator Schumer and tell him this is urgent. The country's going to collapse if we don't fix this problem. Why hasn't the majority leader brought up the bill that all of y'all voted for to fix this problem? It's never going to be brought up. These subpoenas are never going to see the light of day. I don't know who's driving the train on your side, but you're driving the committee off into a ditch.
Some harsh words there from South Carolina Senator Lindsey Graham about Democrats' approach to Supreme Court ethics. We've been speaking with Bloomberg News' Emily Birnbaum about the newly approved subpoenas. Emily, why are Republicans so mad about what's happening here?
First, they say this is a politicized move against private citizens. They say Democrats are just really mad about recent Supreme Court decisions, such as overturning the federal right to an abortion. They say it's not about ethics or disclosures at all. They say it's especially an effort to harm the reputation of Clarence Thomas, one of the more conservative members of SCOTUS. But second, there is the issue of how important Leo and Crow are to the GOP. So according to one count from an advocacy group, the Senate Republicans on the committee alone received over $450,000 in donations from Crow over the years. And Leo, too, has been such a leader in fundraising, shaping the conservative legal movement. They owe a lot of the party's recent wins to him. So there's also an element of loyalty. Ted Cruz called both of them patriots at the markup.
Now, Senate Judiciary Chair Dick Durbin had to use a surprise procedural move to authorize these subpoenas. You mentioned before that, during the committee that's been pretty contentious, Republicans walked out of the room. Can you describe what that process looked like? It hasn't been pretty, right?
It definitely hasn't been pretty, and it was hard to follow even as it was happening. But basically, Republicans filed 177 amendments to the subpoenas. So that was an effort to gum up the works. Ooh. And then at the beginning of the markup, they invoked something called the 2-hour rule, which people don't really use a lot in the Senate. But it means what it sounds like, that the meeting could only last 2 hours. So that was another effort to delay authorizing the subpoenas. You heard Graham earlier saying, we can do this every single week. We'll just keep doing this every Thursday forever. But Durbin put his foot down at the very end of the 2 hours. He just called a vote on the subpoenas. They hadn't voted on any of the Republican amendments. Republicans had been delaying, talking about other things, making statements that they've made before about all of this. And as Durbin was starting to call the vote, Republicans quickly got up and ran out of the room in order to deny Democrats the necessary number of minority senators present. So now, of course, Republicans are saying, well, that wasn't even valid. You didn't have a quorum. They also say that the actual vote took place 2 minutes after the 2-hour rule was up. So it was 12:02. So it's all really dicey. Durbin said something funny, though. He said, if I were in their position, I'd also be saying that. But he says the vote was completely legitimate.
And how did those differing versions of how this all played out, how does that get worked out?
I think that there's a lot of conversations happening behind the scenes right now. I think that the committee is going to need to talk about this again in a public setting, because if really there is a procedural issue with these subpoenas, there's not a point to authorizing them, because then they could just get beat really quickly in court. Mm-hmm. So I actually think we just don't really know what comes next just yet.
Now, we heard some of the criticism from Senator Lindsey Graham, but what about the response from other Senate Republicans? I mean, are they all on the same page here?
They do seem really united on this. So Senator Cornyn, at a certain point during the markup, said that Durbin was destroying the Senate Judiciary Committee. He said, "Congrats, you've destroyed all of this goodwill that we've built up," because there is a history of bipartisanship on the Judiciary Committee, specifically in the Senate, at least. And yeah, there was a lot of complaints from Senator Tom Cotton, from Marsha Blackburn. They all got up at the same time and walked out of the room. So I really think that they have made it clear they're willing to go to bat against these subpoenas and expend a lot of political capital fighting them.
So you sort of described what happened at the end of the hearing, as Republicans all sort of got up. Was it a surprise to them that Senator Durbin was just going to go ahead and move forward with the vote? Was that something that they weren't expecting? Was it something you were expecting?
No, I wasn't expecting it. Other reporters in the room weren't expecting it, and I don't think Republicans were either. They clearly knew what to do when it started. I think that they know the rules of their own committee really well, but I think it was actually a surprise, which is hard to pull off.
Yeah, definitely in Congress. So what happens now? What should we expect from the Senate?
So still a little unclear. They need the 60 votes to formally approve the subpoenas. So that is a huge hurdle. And they will probably have to maybe even vote again if they decide that this quorum issue is real. They're going to be fighting about it in public and in private for weeks to come. So I wish that there was a more solid answer, but they're getting into slightly uncharted territory.
Gotcha. So, we talked a little bit, earlier about the Supreme Court Ethics Code, and you mentioned that one of the concerns was enforceability. Do you have any indication from the court that they're going to be speaking more on this topic, or is what they've given us sort of all they're going to give us, and this will have to play out in other parts of the debate?
The language from Chief Justice John Roberts describing the ethics code was pretty final. It basically was a message that something along the lines of, critics have been saying that we don't have ethics standards the way other courts and judges do in this country. So we're just putting this all down in writing to show you, actually, we do have these standards. We've been abiding by them forever. So it wasn't even, here we have something new. It was, no, we have all of this. Let us just show you our work a little bit. So I don't have an indication that there's going to be an enforcement effort, like a oversight board created or anything along those lines. But a lot of people thought that SCOTUS would never even respond to a lot of this ethics criticism, and they did. So it's a really new era in that way.
Yeah, I wanted to ask you about that response. It seems like a lot of people were clamoring and, really pushing them to release something, and then they did. And then the enthusiasm about that, I guess there really hasn't been that much enthusiasm about the code that was released. So what are some of the concerns that critics have about what the Supreme Court actually put out?
I guess the first concern from critics and from activists is that they're saying one thing and doing another. So, they say that they don't get into situations that could appear to create a conflict of interest. So then it becomes maybe a matter of opinion. What is an appearance of conflict of interest? All of these justices spend a lot of time making speeches at the Federalist Society. Could that potentially violate ethics standards? It's a little bit unclear.
Well, a lot of unknowns still. That'll definitely have to keep watching this situation, but our thanks to Emily Birnbaum. Coming up next on the Bloomberg Law Show, we'll dive into the salary wars playing out at big law firms. I'm Kimberly Robinson.
And I'm Lydia Wheeler. This is Bloomberg.
You're listening to the Bloomberg Law Podcast. Catch us weekdays at 10 p.m. Eastern on Bloomberg.com, the iHeartRadio app, and the Bloomberg Business app, or listen on demand wherever you get your podcasts.
I'm Kimberly Robinson.
And I'm Lydia Wheeler. We're in for June Grasso, who's out this week. Let's get now to the big law salary wars. Joining us to discuss is Bloomberg Law's Meghan Tribe, who covers lawyers in the legal industry. Meghan, what are the salary wars? I mean, it seems like this is something that we go through every year or so that I keep hearing about. So what's happening?
Well, I think wars this time around might be a little strong, but you're definitely right that we've seen this movie play out before. So kind of pulling back a little bit, the way that Big Law compensates its young lawyers is very nuanced. So generally, all top big law firms follow a seniority-based pay scale for their young lawyers, and all of the top firms tend to move in lockstep with one another, meaning that if one firm raises salaries, so in this case, Milbank, then the rest will likely do so as not to lose out on talent. The salary war piece comes in as it's a way for firms, the most profitable firms, to set themselves apart from the rest of the pack. You absolutely recall 2021 and 22 when we just saw a series of salary increases all coupled with bonus announcements. So special bonuses on top of annual bonuses, all of which were increased for firms to really, one, reward their attorneys for doing really insane amounts of work during that time, but also as a way to be competitive. So there's definitely a bit of flexing on the part of firms that happens every time something like this happens. But yeah, this time around, it definitely was shocking and surprising. I think most would agree.
So I want to get to that shocking bit. But first, I just want to be clear that we're talking about associates, not partners here. So what is it that these attorneys normally look like? I mean, are they really experienced? Are they just starting out? Is it everything in between?
It's everything in between. So associates can range from, a first year who just came out of law school that will make now about $225,000 a year to more senior associates who have about 7 to 8 years under their belt. And they'll be making anywhere from between $420,000 to $435,000 a year now.
You mentioned that Milbank was the firm that really kicked this all off. Can you tell us a little bit about that law firm and exactly what they did? What was their increase?
Sure. So Milbank really has made it a point in recent years to become a leader in associate compensation. Going back to 2018 when it raised starting associate salaries to $190,000 a year. It was also the first to increase associate salaries in early 2022. And its chair, Scott Edelman, in this recent announcement where they bumped salaries, I believe $10,000 across the board, said in an internal email announcing those increases, he cited high levels of activity across the firm driving those pay raises.
Alongside with those salary bumps come an increase in the bonus scale. You mentioned that a little bit. What kinds of bonuses are these lawyers eligible for? What are we talking about here?
So that's just one thing. One note, there wasn't any increase in bonuses this year, so it stayed the same. The scale stayed the same as we've seen over the past 3 years, ranging from $15,000 to $115,000 for the most senior associates. So these are annual bonuses. These are awarded to associates who have been at the firm for the calendar year, who have met their billable hours requirements, and in some special circumstances, other requirements that the firm has.
This seems like a lot of money that we're talking about here. So what is expected from these attorneys in return in order to justify those big salaries?
On the associate side, the trade-off is pretty clear. You'll be working at a top law firm, and that on your resume alone is able to open doors in your legal career. But the flip side of that is you are working a lot. Most top law firms expect associates to bill anywhere, around 2,000 hours a year. And that's not including just general, run-of-the-mill admin work. So you really are kind of turning over a big portion of your life to these law firms in return for these salaries.
We talked a couple of times about this being a surprise move from Milbank. Was that related to the state of the legal industry? And if so, what does that look like right now?
It's interesting that it comes at this time. So bumps typically happen during boom times, as we saw in 2021 and 22 when M&A activity spiked to an all-time high. And there really weren't enough associates to go around to do the work at these law firms. So Milbank's move now comes amid a downturn for many firms, as we all see transactional activity hasn't really come back. Some firms have laid off associates and delayed start dates for first years. Lateral associate hiring is down. But what this likely shows is that there are some firms that are getting a disproportionate share of the work that's available. So in a recent study by Wells Fargo, net income among the biggest 50 firms in the U.S. was up about 5.2% on average throughout the first 9 months of the year. And then for the next 50 largest firms, net income was down 0.7%. So there's what we're seeing is there's this disparity, and the salaries increases are kind of reflective of that.
So what has the response been from other firms? Are they taking things further, or are they meeting Milbank here on this salary?
So it was interesting. After Milbank's initial announcement, there was a fair amount of silence among law firms. And it wasn't until Cravath, which has been the leader for decades in associate compensation, announced its scale that we started to see law firms say that they would be matching. Now I think we're at about over a dozen firms that have said that they would be matching this new salary. So as we wait and see what other firms will do, it'll be interesting to see which go along with this scale and which don't. And perhaps we'll see the long anticipated bifurcation of salaries amongst law firms.
Mm-hmm. So it occurs to me that these new salary and bonus scales, whenever they happen, they're sort of a one-way ratchet. Do they ever go down, or is it always just up, up, up?
So that's a really interesting question, and it gets at an interesting point about this recent round of salary raises. Associate salaries haven't gone down, at least over the last 2 decades. They're a static cost, and it typically stays that way, and firms really don't typically walk them back. But bonuses can vary year to year depending on the profitability of the law firm. So, for example, in 2009, after the bottom fell out in the global economy, bonuses fell from $35,000 for first years just down to $7,500. Salaries, however, stayed the same. So by putting more into bonuses year over year, it allows the firm to reward associates when things are good, but without having a fixed cost when times are bad. That's why this move by Milbank is really surprising, because it's locked the industry's top firms into a new scale that they have to pay that isn't discretionary during a non-boom time. So it'll be really interesting to see what happens in the coming months.
So why did Milbank do this to start with? Like, what was their reasoning for wanting to up the salaries here?
They said that they had high levels of activity and they wanted to reward their associates. The other thing I think they alluded to in their email was cost of living. And so inflation being what it is, I believe now starting salaries have met inflation. Those were their main reasons why. And, not to go back to the original point, but that this is kind of a way for the top firms to show that they are the top firms.
So I wonder if you know what the whole effect on the legal industry is going to be after this latest round of salary raises.
So it'll be really interesting to see what the fallout is from this. I think it definitely makes the statement that not all firms are similarly situated. Some law firms can match without issue. Others will have a very tough time if they decide to do so, and a hard sell to their partners if they want to match. One thing to keep in mind, though, is that when firms do announce increases like this, they have two options to pay for it. One is to require associates to work more hours, or the other is to increase billing rates. And we've seen over the past decade that major law firms have consistently raised their rates at significant levels, which has helped some maintain revenue growth even during times of flat demand. So revenue gains this year were largely driven by the average billing rate increase of about 8%, according to that Wells Fargo survey. That is the highest growth in billing rates that Wells Fargo has seen, and it's anticipating that rate to stay the same into next year. So if firms feel confident that they can continue to raise rates, perhaps they will feel confident enough to increase associate salaries. One person I did talk to, though, did say that the pairing of the both, the salary increases as well as the rate increases, might be a tough sell to some clients. And, it'll be really interesting to see what kind of conversations are being had right now and into next year as law firms determine where to go from here.
So far, we've been focusing on associate pay, but let's turn now to partners. Meghan, if the associates are making these big numbers, how much are the partners making?
Well, partners are making a fair amount of money these days at the nation's top firms. I think that's the easiest way to say it. Last 2-3 years, we've just seen enormous records pay per equity partner. So equity partner is a partner that owns a stake in the law firm. So when we think about traditional partnerships, that's who we're referring to. We've seen reported figures between 6-7 million, but we've also, beyond that, heard of compensation packages for top lateral talent being in the double digits in the millions. So it's definitely rising, and at some of the nation's top firms, it's enormous.
Wow. And you mentioned before that these higher salaries just for associates requires them to do a lot more work. But what about for partners making these higher salaries? I mean, isn't it once you make partner, you get to step back a little bit, or is there more work involved?
Oh, there's definitely more work involved. So think of it as, you're climbing up the ladder, and at most firms, traditionally, it's around the 7th or 8th year, sometimes 9th, that you will be eligible for partnership. And once you are a partner or an equity partner, there's different scales within the partnership at a lot of big law firms and ranges in terms of salaries. The big astronomical figures that we're talking about, those are really the superstars, the rainmakers. Those are really like the superstars who have huge clients, whether that be a big private equity firm, or a big public company. Those are the people that are the ones getting these big figures. But there's a big range within, partnerships. There's also, something called a non-equity partner, which they don't have equity stake, and part of their pay is salaried. So there's a bunch of different ways.
Sounds complicated. One thing that you talked about before, and you've done a lot of reporting on this, is about billing rates and sort of the effect that has on, on associate salaries and, work. Can you tell us what those look like for some of the most sought after partners?
So for some of the most sought after partners, clients are looking at a bill worth, with a top partner billing out at about, $18,000 to $2,000 an hour.
Wow.
Yeah.
Wow.
But these are really the superstars, the partners that you want on your case, especially when it's a bet the company case. But then after that, the billing rates for partners can range anywhere from, $1,000, $1,200, up to that. And again, we're talking about the top firms, and associates can go from $750 to $1,000, depending on experience.
Is that sustainable for the legal industry, though?
It has been, and it seems like it would continue to be as clients know that, they can call up X firm and get the result that they want. Billing rates have consistently gone up year over year, and it doesn't look like there's any indication that it'll slow.
Well, that's Bloomberg Law's Meghan Tribe. That's going to do it for this edition of the Bloomberg Law Show. I'm Kimberly Robinson.
And I'm Lydia Wheeler. This is Bloomberg.